All right. We have the attendees rolling in. We're at 35. We have about 65 attendees registered. Hello, everyone. We're just waiting for all the attendees to come in, so just giving a little bit more time. Hello, everyone. For those of you just joining us, we'll be starting shortly. All right, ladies and gentlemen, we have about 50 attendees. It's a pretty huge amount that we have tonight. I'm going to go ahead and get this webinar started. Good evening, everyone. I'm Marlon Pangolinan, Senior Planner with the Planning Department, and welcome to the 2022 Community Planning Group Orientation Workshop. This training is mandatory for all new Community Planning Group members. Thank you for being here and volunteering at each of your respective community planning groups. First off, I'll be explaining a few housekeeping items before we begin. For those of you who are new to Zoom webinar, all attendee lines have been muted, but feel free to use the Q&A function located at the bottom portion of your screen to send questions at any time during the session. We'll be holding verbal questions at the end of each agenda item, if time permits, and at that time you may use the raised hands feature, also located at the bottom of the screen, to ask your question. During the course of the council policy presentation, we will be polling attendees with quiz questions. A prompt will appear before your screen where you can simply select the correct answer using your cursor. Staff will then tally the responses and reveal the correct answer. The workshop is being recorded so that it can be viewed for anyone who can't make it tonight or for anyone who would like to view it again at a later date. A link will be posted on the city's webpage. Here's our agenda tonight. After some welcome greetings, we'll get into the roles and responsibilities of the city's recognized community planning groups, followed by a presentation by Development Services Department staff on the development review, permitting, and environmental review processes. Then we'll take a brief break. Our last item will be a guest speakers Q&A panel with members of the Planning Commission, several planning group chairs, and staff, where we'll have a few discussion questions for our guest speakers and open it up for those of you in attendance to ask questions as well. I would now like to hand it over to Heidi Von Bloom, Planning Director, who will provide you with an overview of how your participation on community planning groups supports the city's work program, and then she will be followed by Hoffman, Chair of the Planning Commission.
Thank you, Marlon, and thank you to all of the community planning group members that have joined us today, and also for your service on the community planning groups. As you're aware, planning groups are a critical function that are part of the planning work that we do, both within the planning department as well as the development services department. And we have staff from both departments here to share with you today. Also wanted to highlight the importance of community planning groups and our public engagement process, particularly with respect to serving as a critical outreach tool to community members that may not have traditionally participated in the process, And so thank you in advance for reaching out to new neighbors that you may not have met and encouraging them all to participate in the community planning group process, which brings more voices to us here in the city of San Diego, both within the Development Services Department as well as in the Planning Department. So with that, I want to thank Planning Commissioner Chair Hoffman for joining us here as well today, and turn it over to him now. Thank you so much for being here.
Oh, thank you, Heidi, and good evening and welcome and congratulations on being elected to your community planning group. For those of you new to your respective board, we hope this evening helps prepare you for your duties ahead. This is a very important role in the overall city planning process. Your planning group serves as the official voice of your community on land use decisions. The City Council only recognizes one community planning group from each community to make recommendations on land use policies and project reviews. As a community group member, your role in making recommendations to staff, the Planning Commission, and the City Council on land use matters provides us with that needed input. So tonight, we will try to provide you with the necessary tools to serve the city and your community effectively, and to ensure that your actions and proceedings comply with state law and city policies. One question that always comes up is how seriously the Planning Commission takes the recommendations of the community planning groups. And the answer is that we take them very seriously. Every staff report we read has the planning group's recommendations and minutes. We review these carefully, and our decisions are influenced by the recommendations that you make. It is very important for us to receive detailed minutes of your discussion and recommendations, especially on controversial projects. The more info and color we have, the better we can incorporate your recommendations into our decision-making process. Most of the time, we concur with those recommendations. However, there are times where we may disagree and go with a different decision. In those instances, the Planning Commission is required to look at land use decisions on a citywide basis, and sometimes the community group recommendation may, in our opinion, go counter to citywide goals and policies. But regardless of our decisions, we take your input seriously and consider it very carefully. So this evening, the planning staff will be conducting the training for City Council Policy 600-24, the Brown Act, and bylaws for the community planning groups. And with that, I'd like to introduce the planning staff here tonight, which includes Marlon Pangilinan, Leslie Henniger, Jeffrey Ryan, Suchitra Lukes, Christy Chasen, and Selena Sanchez Bailon. And with that, I'll turn it back over to you, staff.
Thank you, Chairman Hoffman. We'll now jump into a discussion on the role and responsibilities of recognized community planning groups, also known as Council Policy 600-24, which will be presented by myself, as well as a few other staff members from the Planning Department. In addition to Council Policy 600-24, we will also be going over other community planning group governing documents such as the Open Meetings Law, the Ralph M. Brown Act, Community Planning Group Bylaws, the Indemnification Ordinance, which provides legal protections to community planning groups, and Robert's Rules of Order, which provides direction on parliamentary meeting procedure. Council Policy 600-24 establishes the overarching framework for community planning groups' operations and provides direction for setting up their bylaws. It provides a set of standard operating procedures and responsibilities for community planning groups. By following the council policy, each group is indemnified by the City of San Diego against legal challenge for a community planning group member or for group actions. In order to be indemnified, individual community planning group members are required to take this training or the electronic version of this training and to follow their respective community planning group bylaws and all provisions of Council Policy 600-24. This council policy also establishes the role of the Community Planners Committee, which is comprised of designated members of each community planning group, which meets monthly to discuss and make recommendations on matters of citywide significance. As a reminder, tonight's session is just an overview of the council policy, so we recommend that each community planning group familiarize yourself with it and refer to it often.
Article 1 of the Council Policy addresses the official name of the community planning group and delineates the boundaries. The majority of your work will be conducted within your community unless there is a citywide policy issue that you are addressing. On occasion, there may be a significant project on the border in an adjacent community that affects yours. As a courtesy, that applicant may present to your community for input. Next slide. The community planning groups are asked to make recommendations on matters related to the general plan or land use plans and forward them to the decision makers. That can include city staff, a hearing officer, planning commission, or city council. Community planning groups review development projects for conformance with their community plan, the general plan, and other city policies, such as the climate action plan. The groups provide a written recommendation to city staff as well as the decision-making body. If you have questions related to project reviews, the project manager in Development Services Department is the responsible staff person to contact. A community planner from the planning department is assigned to each community group to provide assistance as needed. For development project reviews, the project managers in Development Services Department are the project's single point of contact. All planning group activities are to be nonpartisan and non-sectarian. The groups may take a position on a ballot initiative, but no planning group can endorse a political candidate. A planning group member may individually endorse a candidate, but in that case, they must act as a private citizen. Timely review. Planning groups should respond in a timely manner for development project reviews, as well as amendments to their community plan. Whenever possible, groups should complete their review by the end of the environmental review process. If a group holds up the timely review of a project, they may forfeit these rights. Next slide.
To keep you all engaged virtually this evening, we're going to do a few polling questions throughout the presentation. First question, who is the main point of contact if you have questions about a project the community planning group is reviewing? Is it A, development project manager from Development Services Department, B, community planner from the planning department, or C, the project applicant? And I have just launched the poll for you guys to go ahead and try to answer the question. I'll give you a few seconds to answer. Okay, last call to answer the poll. And the answer to this question is A, development project manager from Development Services Department. You all got that correct. The community planning group reviews development projects for conformance with their community plan, the general plan, and other adopted land use plans. For project reviews, DSD's development project manager serves as the project's single point of contact. Next slide.
Community planning groups should have between 12 and 20 members, unless specifically approved by City Council. Recognized members are members elected by eligible individuals of the community or appointed as specified in a group's bylaws. Eligible members must be at least 18 years of age and be qualified, affiliated with the community as a property owner, resident in the planning group's boundary, or local business owner or their designee. Additionally, some planning group bylaws allow for additional member categories and or for appointed members, such as students in Tierra Santa. Members are elected to serve either 2 to 4-year terms or 3-year terms as specified in the bylaws, with expiration dates in alternative years to provide a continuity of the board. Members are term limited to 8 or 9 years total. Members who have at least 1 year break in service will be eligible to run again for election. Term limited members, that's those who have served the previously mentioned 8 or 9 consecutive years, may be reelected if there are no new candidates running for a vacant seat and if they receive over a 2/3 votes cast. Members must retain eligibility during the entire course of their term. Violations of provisions of a community planning group's bylaws, council policy, or the reference Brown Act provisions may risk loss of indemnification or removal from the planning board. Next slide.
Article 4 describes the process for determining when a vacancy occurs, how to fill vacancies, and what to do if your planning group cannot fill vacancies. When vacancies occur, your group will first declare a vacancy. The planning group will find that a vacancy exists if a written resignation is received by the group, or if a member has 3 consecutive absences, or 4 absences within a 12-month period between April and March of each year. Vacancies should be filled within 120 days after a vacancy is declared, and in accordance with your bylaws. The new member's term will be the balance of the vacated term. Note that a single vacancy may be filled by appointment of the group, but multiple vacancies should be filled by a special election. If your group is unable to fill a vacancy within 120 days, and if your group has more than 12 members, the planning group can either leave the seat vacant until the next election or amend its bylaws to permit a decreased amount of membership. All planning groups require a minimum of 12 members unless the group receives special permission from City Council. Next slide. Article 5 discusses the planning group election process. Elections are held in March of each year or every other year. To be eligible, candidates must attend a minimum of 1 or more meetings prior to the February meeting of the full planning group. Some planning groups require more attendance to be eligible as a candidate, so please consult your bylaws. Also, the planning group is expected to make good faith effort to advertise elections and solicit potential candidates from the entire community. Voting to elect planning group members is by secret ballot, and election ballots must be retained as outlined in your bylaws. Proxy voting is specifically prohibited. Some planning groups provide for voting on multiple times and or on multiple dates. Your planning group bylaws will have specific details for your group. The city has issued an interim policy on election procedures to allow that they be conducted online or at drop-off locations. Normal election procedures should resume once we begin meeting in person again. Next slide.
Question number 2. Can the member of a community planning group allow another member of the planning group to cast a vote for them when they are absent from the meeting? Is it A, yes without restrictions, B, yes but only if the member has a notarized letter granting him or her permission to vote, or C, no, proxy voting is not permitted? I'll leave this up for a few seconds for you guys to answer. It looks like you're leaning pretty heavy in one direction. So I'll go ahead and end this polling. And the answer is C, no, proxy voting is not permitted under Robert's Rule of Order and Council Policy 600-24. Next slide.
Duties. It is the primary responsibility of the CPG to work cooperatively with city staff throughout the planning process and to conduct meetings as civil public decision-making processes that are open to all members of the public. Community planning boards are subject to the Brown Act. Next slide, please. The Brown Act is intended to ensure transparent and open discussions and votes in the government and that there is meaningful public access to decision-making. The Brown Act requires that meetings be open to the public and conducted in accordance with an agenda available in advance of the meetings. All substantive discussions about agenda items or possible group positions on agenda items must occur at noticed planning group meetings. For noticing requirements, these include 72 hours for posting an agenda for a regular meeting and 24 hours for a special meeting. You must also avoid seeking a collective concurrence. Accordingly, communications between planning group members outside of public meetings are prohibited per Council Policy 600-24 and the bylaws. Of importance, many issues arise over email communications between planning group members. Please avoid email communications that provide opinions on matters that can come before the planning board. Only factual information can be shared. Next slide. Regular meeting agenda posting. The agenda shall be posted to an accessible location to the general public for the entire 72-hour noticing period and shall include information on how a request for accessible accommodations may be made. If your group has a web page, the agenda must be posted there as well. As required by council policy and the Brown Act, there must be a quorum of members present in order to convene a meeting, including voting on action items. A quorum is defined as the presence of a majority of the filled seats of the planning group. If a quorum is lost during the meeting will have to be adjourned. To encourage public attendance at meetings, no member of the public can be required to register or provide any information or to pay a fee for admittance. Any attendance list or request for information should clearly state that the completion of such information is voluntary. For public comment, all meetings must allow for public comment on issues not on the agenda, as well as an opportunity for the public to comment on individual agenda items. Time limits may be placed by the chair when managing the meeting agenda. Non-agenda public comment is not debatable. Meetings are adjourned when agenda items are procedurally dispensed with or due to a lack of quorum. A new agenda must be prepared unless there are items continued to a special meetings within 5 days. Consent agenda. CPG's community planning group meeting agendas may contain a, quote, consent agenda section containing items that will be quickly dealt with near the beginning of the meeting by a vote by the planning group, provided there is no one interested in public comment. Avoid seeking a collective concurrence. Accordingly, communications between planning group members outside of public meetings are prohibited per Council Policy 600-24 and the bylaws. Of importance, many issues arise over email communications between planning group members. Next slide. For social media, again, please avoid email communications that provide opinions on matters that can also come before the planning board. Only factual information can be shared. Generally speaking, the golden rule is for social media is just to not engage. Next slide.
Question 3. If a community planning group has 15 seats, but only 2 of those seats are vacant, how many members need to be in attendance in order to conduct business or have a quorum? Is it A, 8 members, B, 7 members, or C, all active members of the board? The poll is available for you guys to answer. We have the majority of the participants answering. Okay, looks like you guys got that right. I'll end the polling now. The answer to this question is B, 7 members. A quorum is defined as the presence of a majority of the filled seats of the planning group. Since there are only 13 filled seats, only 7 members are needed to have a quorum. Next slide. Question number 4. How long can the public comment on an agenda item go for? Is it A, indefinitely, B, the community planning group chair can place time limits, or C, 1.33 minutes? Okay, looks like you guys answered this one really quickly, and you all got the right answer. The answer to this one is B, the community planning group chair can place the time limits. All meetings must allow for public comment on issues not on the agenda, as well as an opportunity for the public to comment on agenda items. Time limits may be placed by the chair when managing the meeting agenda and should be announced during the meeting before public comment has begun. Time limits are important for keeping your meeting on schedule. Next slide.
All right, to continue on with additional duties listed under Article 6, regarding development project review, the applicant should be informed each time the group will discuss a project and be provided with an opportunity for a presentation. Planning groups may not require applicants to submit additional information and materials beyond those required as a part of the city's project review process. Regarding action on agenda items, Under Council Policy in the Brown Act, an item not noticed on the agenda may be added if either 2/3 of the entire elected membership or every member, if less than 2/3 are present, determined by a vote that there is a need to take an immediate action. However, it is good practice to avoid modifying agendas to add items due to public notice concerns. Additionally, planning groups shall not use secret, proxy, or absentee voting, such as by phone or email. Minutes should also reflect the prevailing opinion and dissenting opinion on action item votes. Regarding special meetings, the planning chair may call a special meeting under unique circumstances, such as to meet a project review or appeal deadline. 24-hour advance posted notice is required, as well as notification of community-specific media. Emergency meetings are specified by the Brown Act for matters related to public health and safety. These matters, however, are outside the purview of a planning group and are not allowed by the council policy. Regarding right to record, any person attending a planning group meeting must be allowed to record or photograph the proceedings, so long as doing so does not disrupt the meeting. In the rare event that an individual is disruptive to the meeting, the planning group may remove the individual or individuals. If unsuccessful, the chairperson may order the meeting room cleared and continue in session on scheduled agenda items without an audience. Representatives of the media may stay. The planning group may readmit individuals who are not responsible for the disruption. Next slide.
Okay, we have two more back-to-back questions. Question number 5. What steps need to be taken in order to add an action item to the agenda during a meeting? Is it A, a 2/3 vote is needed from the planning group? B, it must be determined by a vote that immediate action is needed on the item? C, the need for action on the item came to the attention of the planning group after the agenda was posted? Or D, all of the above? Okay, you guys are definitely moving in the right direction. And I'll do last call to answer this question. And the answer to this question is D, all of the above. To change an item on the planning group agenda from an informal item to an action item, all of these steps must be met. This circumstance is rare, but there may be a time when a hearing date is quickly approaching or a project review cycle is closing soon and an action item needs to be added to the agenda at the last minute. If this happens, all of the above steps need to be taken. Next slide. Question 6. Can a community planning group organize a special, or how can a community planning group organize a special meeting? Is it A, with an email 2 hours before the meeting? B, chairs may call a special meeting within 24-hour advance public posted notice? Or C, with a phone call to all members of the board? You all are voting for the right answer, so I'll go ahead and end this poll now. The answer to this question is B. Chairs may call a special meeting with a 24-hour advance posted notice. The 24-hour advance notice should also include noticing the planning group members and community-specific media. The notice shall identify the business being discussed at the meeting. No other business shall be considered at this meeting, and non-agenda public comment is not required. Next slide.
Regarding subcommittees, recognized community planning groups are encouraged to establish subcommittees when their operation contributes to more effective discussions at regular planning group meetings. All meetings must be open and accessible to the public. Subcommittee meetings are noticed at the regular planning group meetings, and reports should also be provided. Standing subcommittees are ongoing subcommittees tasked with reviewing specific issue areas such as development review and are listed in a group's bylaws. All standing subcommittees are subject to the Brown Act's public noticing and meeting requirements. Ad hoc subcommittees are established for a defined task or period of time to work on a specific issue and are disbanded at the conclusion of the project. Regarding subcommittee composition, Subcommittees should contain a majority of members who are members of the planning group, but less than a quorum. Non-planning group members may also be included in a subcommittee. Regarding meeting documents and records, meeting minutes are to be prepared for all meetings. Minutes should be submitted to the city for posting within 14 days after approval by the planning group. At a minimum, state when the meeting was convened and adjourned, describe any action taken by the group, identify public comment on action items, and record the voting results. Again, be sure to reflect the prevailing and dissenting opinions on action items. Planning group records must be retained for public review. The planning department will keep archives of agendas and minutes for 2 years, but we recommend groups keep records for a lot longer. Next slide.
Okay, last question of the evening from us. If a subcommittee votes on a project, can the vote bypass the community planning group and move straight to the city as a formal recommendation? Is it A, yes, but only if the community planning group attempted to take a vote on the project but was unable to get a quorum? B, no, in no case may a subcommittee recommendation be forwarded directly to the city as the formal recommendation? Or C, yes, without restrictions? All right, everyone, get your answers in for the last question of the evening. And I'll go ahead and end the polling, and you guys definitely were on the right track. The answer to this is B, no. In no case may a subcommittee recommendation be forwarded directly to the city as the formal recommendation. Per Council Policy 600-24, the city will not recognize subcommittee recommendations if presented directly to the city without being voted upon by the Community Planning Committee. Next slide.
Okay, well, I swear we're almost done with Article 6. Regarding recusal from voting on an action item, members must recuse if they or their immediate family have a known direct financial interest in the outcome. This is different than a broader community interest affecting other members. The members must state the reason of their recusal. The recused member does not count towards the quorum. This is critically important if your meeting has just enough members for a quorum. If someone recuses in that case, you no longer have quorum for a meeting at the vote. The recused members do not participate in the discussion at all. In fact, it is customary that the member leaves the planning group seating area. I'm going to try turning off my camera to see if that helps with some of the bandwidth issues. One moment. Regarding abstentions, members may declare their intent to abstain from a vote both at the onset and at the discussion, at the onset of the discussion or after the presentation, although stating up front is preferred. If you have a possibility of conflict of interest that could be construed as posing it as an advantage or a bias, you should state your intention to abstain before the presentation. If you do not feel you have been given enough information over the course of project discussions, you may abstain at the conclusion of the presentation. Note, abstentions should not be used to avoid voting or taking a position on an item. As a planning group member, you have a duty to participate in voting. Next slide. Community outreach. Planning groups have been formed and recognized by the City Council to make recommendations to the city. As such, you have a duty to conduct public outreach in order to seek broad community opinions, viewpoints, and interests. Regarding documents, your planning group is responsible for maintaining a current roster of your members and for providing a copy to the city. Additionally, by the end of March every year, the group shall provide a written annual report summarizing the group's accomplishments and anticipated objectives for the coming year. Planning groups may also develop a policy for financial contributions from the public. However, remember, no membership dues can be charged and no fee can be charged to attend a meeting. Next slide.
Officers, Article 7, Community planning group officers are typically elected in April after the March elections and consist of a chair, vice chair, and secretary. However, bylaws may specify other officers as needed. The chair is the principal officer of the planning group and sets the agenda and presides over meetings. The chairperson is also the primary point of contact between the group and the city. The vice chair performs the duties and responsibilities of the chairperson in their absence. The secretary is responsible for the group's roll call, recording minutes, and maintaining attendance records. In addition, some groups may have additional officers, such as a treasurer that performs some of the administrative duties. These will be specified in the bylaws. Next slide. And I'm just going to turn off my screen again as well to see if it improves the volume. Article 8 allows for a community planning group to include procedures tailored to specific aspects of their operations. This also allows for more detailed guidelines than the standard bylaws show. Topics may be addressed briefly in other parts of their bylaws, but in more detail here. One group put their election procedures here, and another added additional recall criteria. Next slide.
All right, so as we've discussed regarding indemnification and representation, planning groups are provided protections for activities conducted under the scope of their responsibility and in compliance with Council Policy 600-24 and the Brown Act. A copy of the indemnification ordinance is provided in the Community Orientation Workshop Handbook on page C85. The city will provide for the defense and indemnity of the individual member, the group, former members, or their duly appointed persons against any legal claim or action provided that the act or omission fall within the circumstances outlined in the ordinance. Next slide. Regarding Brown Act remedies and penalties, by adopting and following bylaws that comply with the council policy, planning groups will be considered to be in substantial conformance with the Brown Act. Regarding Council Policy 600-24 violations and remedies, alleged violations of the council policy by an individual member of a planning group will be investigated by the group following specific procedures included in the group's bylaws. A key purpose of this training is to help prepare you to comply with your group's bylaws, Council Policy 600-24, and the Brown Act. So a few major takeaways from tonight's training. 1, transparency in board member meetings. Be sure to notice regularly scheduled meetings at least 72 hours in advance and notice special meetings at least 24 hours in advance. 2, avoid discussions outside of meetings. 3, timeliness. Formulate recommendations on policy matters and project reviews and send these on to city decision makers in a timely fashion. This concludes our overview of Council Policy 600-24, the Brown Act, and the bylaws. Back to you, Marlon.
Suchi, here are a list of helpful resource links that includes where you can find a full reading of the Council Policy 600-24, a schedule of future trainings and workshops for community planning group members, and the Brown Act. And always feel free to reach out to your assigned community planner as a resource as well. Right now, that concludes our council policy presentation, and we do have some time to answer a couple of questions. Do we have any questions, Suchi?
Yes, we do. And I first want to acknowledge a few comments in the chat about the audio coming in choppy. Apologies for that. We will be posting the materials on the city's website, and so we'll be sure to circulate that link afterwards. But we do have a question. Can you please further describe what constitutes a conflict of interest?
Sure. A conflict of interest is defined by the city attorney's office as someone, a board member, who stands to gain financially from whether a vote is a yes or no. It is, in that case, the board member should recuse. It is not defined by religious questions or political persuasions. It's purely based on financial gain.
All right, thank you, Leslie. So we also have a few other questions asking about the status of community planning group reform and what the status of those changes might be.
Okay, as many of you know, that the reforms are being processed with Council District 1 as the lead entity on this. The council member as well as the staff have been making their rounds to the various community planning groups as well as the Community Planners Committee on the status of those proposed reforms. Once those are adopted, we will be coordinating with the City Council on implementing those.
All right, thank you, Marlon. I see a few other questions coming in. I believe we have time for one more. So the question is on the consent agenda, can either a member of the public or a community planning group have a consent agenda item removed from the consent agenda? So to clarify the question, it's asking about consent agenda and if members of the public have the opportunity to remove an item from consent.
Yes, so on the consent agenda, usually planning groups will identify, usually specifically on their agenda, if anyone from the public would like to further discuss items on their consent agenda. And usually if they do receive a request to discuss those further, they automatically remove those from their consent agenda and discuss them as part of their agenda that evening, or in some instances, I know with the La Jolla Community Planning Association, when items are pulled from the agenda, they are usually placed for discussion at the subsequent meeting or the following month. So it kind of depends on how the bylaws dictate how your consent agenda functions.
Thank you, Marlon. So we're also getting questions related to project review, and that tees us up for one of our other agenda items. And just want to check, Marlon, if now we'll be transitioning over to the Development Services Department.
We will in a minute. Why don't we get one more question? I think we have time.
Okay, all right. So we do have a question about expanding on recusal and how does that affect the status of a quorum?
So recusals are not included in the quorum. Remember, the planning group member has to step away from the board. So in a sense, that member isn't part of the board for that specific agenda item to which they have a direct economic interest and have to recuse. So then again, the quorum is based on those present members on the board, and of course on the non-vacated seats.
Great, thank you, Marlon. Do we have time for one more question?
We do, Suchi. Yeah,
okay.
Go ahead.
All right. So one is a clarification. Did this meeting replace the what we have called in the past the COW, the Community Orientation Workshop?
Yes, this is an update, and this year we're calling it the Community Planning Group Orientation Workshop, minus the spotted heifer, I think. But so yes, this will replace it. If everyone who attends this evening will receive a certificate afterwards and show so they can demonstrate to their respective community planning group that they are indemnified. And equally for folks, if you know folks, new members that were elected to your group that are not able to meet tonight's meeting, there will still be the online training on the city's webpage.
All right, thank you. So we did also get a question about the community plan, and can someone from the team clarify how amendments to the plan work?
Arlen, do you want?
Yeah, I'll go into that. I'm kind of working on a couple myself. So the community plan amendment process, obviously the community plan for each of the respective planning groups is an adopted city approved document. In order to make those changes, that's processed through a city council approval, ultimately. But first, what needs to happen is an initiation process. And that starts with the Planning Commission. And staff will bring forward a proposal to amend the plan to the Planning Commission. The Planning Commission will essentially consider the proposal and then provide a decision on whether that's a good idea to evaluate the change in the plan. So there's a number of factors that go into that. There's actually 3 criteria in the general plan that are identified, which one criteria is consistency with policies in the general plan and the community plan, if there's a community benefit resulting from the proposed amendment, and 3 public facilities appear to be available to address the change in the community plan. So once that's initiated, the applicant will submit their development project. Staff will also review the project based on issues that were identified in the initiation hearing with the Planning Commission. Then that project will go forward to the Planning Commission for a recommendation to the City Council. And then the City Council would then hear the project along with the plan amendment and then provide a decision on whether to approve the proposed project and the amendment.
And I would just add to that, Marlon, that, and you know this because you're working on them, but any community plan amendment has to have environmental review consistent with it or concurrent with it. So by the time that the project goes forward to the decision maker, Planning Commission and the City Council, they have the results of the environmental impacts.
Oh, and then I also wanted, sorry, Leslie. Wanted to also add that didn't want to forget about the community planning groups. So the community planning groups provide a recommendation on the initiation of the community plan amendment, and then when the amendment and the project come forward to the Planning Commission and then eventually the City Council, then a recommendation is provided by the planning group on whether to support the project and the plan amendment going forward. So didn't want to forget about you guys.
Suchi, we have time for one more if you want to find a good question.
Sure. We have several questions. So one is, can we clarify what the community planning group's role is in the budget and CIP process?
Do you want me to try that, Marlon?
Oh, go ahead. I assumed you were going to answer that.
Mm-hmm. Okay, I'll give it a try, folks. So the community planning groups do receive projects, private projects, as well as public projects, which would be a CIP, which would be a city project, and they will come before your group and request to be put on your agenda, and you'll have city staff come before you and present the project, and then your group will review it as you would a private project, and then make a recommendation or work with city staff if there's in-depth issues, and then ultimately make a recommendation back to the decision maker.
If I could add to that, this is Tate Galloway. I'm the interim deputy director for the department. There's a council policy that does ask that the city asks what priorities planning groups have for improvements as part of the CIP process. That also does occur. So that information is then taken and considered and then ultimately decided on which projects may get included in a future CIP.
Great, thank you all. So we do have another question about access to community planning group meetings and if there's any guidance on in-person, hybrid, or virtual only at this time.
Well, I think Suchi can probably best answer that one, although I'll answer it for you, Suchi, and you can dovetail in. University is currently going through a community plan amendment, and last month you had your first in-person meeting, and then it was also televised. So Tate, I don't know if you want to jump in on that in terms of the regularly held community planning groups. Is there any move to have them go back in person, or is there anything preventing them from going back in person, or will we continue to do, Zoom or possibly a hybrid?
So the changes that were made recently to the Brown Act do require that monthly that the body makes a determination whether or not that any emergency situation still exists as to COVID or any other issue that would prevent them from meeting in person. So I know there's been a number of groups that have done that at least monthly to continue to meet online. Other groups have made a decision to go ahead and hold in-person meetings. And whether or not you want to do that, such as a city council, as a hybrid meeting, that would be upon the individual planning group to work out the logistics for that. But at this point, it's really at the discretion of the planning group as to how they want to proceed with that, whether they're doing online or in person.
Thank you, Tate.
Okay, we'll move on to our next portion of our meeting. So I wanted to thank everybody for those questions. And so our next item is a presentation from staff in the Development Services Department. And after the presentation, we will also have some time for some Q&A and then take a 5-minute break and then continue with our last part of the evening, which is a guest panel Q&A. So let's try to.
Hello, everyone. Can you hear me okay? Excellent. Welcome to the Development Services portion of the evening. I'm Travis Cleveland, and with me today are Elizabeth Shearer-Wynn, Program Manager over Environmental Analysis, and Michael Prinz, Program Manager in Land Development Review. Next slide, please. Before I really get started, I'd like to call your attention to our many online resources. There's obviously many more here than I have time to discuss, so you can check them out in your own time with a copy of the presentation. But I'd like to call your attention to two, which I've highlighted here in red, Excella Citizens Access and our online maps. Next slide, please. Discretionary projects submitted on or after December 20th can have their status tracked on Excella Citizens Access. We also call this OpenDSD 2.0. Excella is the city's new online project tracking and electronic submittal portal. It's designed to give up-to-date project status and tracking information. A login isn't required. You would have to log in if you were submitting a project, but you can just look. It also shows all zoning and related geographic information on a project with just a couple of easy clicks. So that's an excellent resource for someone reviewing a project such as yourselves. Next slide, please. Our zoning map page has a link to the zoning and parcel information portal where you can enter an address and receive zoning and related parcel information. It also has a link to our Open Counter application, which can help people to find locations for projects or businesses based on their characteristics and tell you what permits you might need for a particular type of project. Next slide, please. All development projects are processed through the Development Services Department. Most projects we see are ministerial, which community planning groups do not see. These are your building permits, demolition permits, right-of-way permits, etc. Basically, if a project meets objective criteria, a permit will be issued. It's an administrative decision by city staff. We asked for community planning group input on discretionary projects, which are required based on project scope and location. For example, a house in much of the city can be developed with only a building permit where the zoning allows. But say in the coastal zone, that house might also require a coastal development permit to ensure compliance with the State Coastal Act. Discretionary permits are just that. They are at the city's discretion to approve or deny, and findings supporting the city's decision must be made for the record. Next slide, please. The Land Development Code defines 5 process levels, 4 of which are discretionary. Process levels are designed to capture the increasing complexity, cost, and amount of discretion involved in a project. Lower decisions are appealable to higher decision makers. Next slide, please. These are some of the discretionary project types you may see as community planning group members. Obviously, this isn't a complete list. We divide or reconfigure property with a tentative map, which usually has other types of permits going along with it. You may be familiar with a conditional use permit. These are where the use might be appropriate in a certain area, so it's allowed, but it may have effects on surrounding properties. So we take a careful look and may put conditions on the project, such as opening hours, etc. Planned development permit allows flexibility in the application of our development standards to make a better project. A coastal development permit is any development in the coastal zone, and then variances and rezones, etc. There's several more here. I just didn't want to fill up a slide. Next slide, please. all discretionary projects are assigned a development project manager. They are the city's project liaison, a single point of contact. You don't have to go and try to figure out who the planner is or who the engineer is. Just call your DPM. They manage the multidiscipline review team. We prepare all written correspondence, reports, and documents and present the project at public hearings. And I always like to note, development project managers are neutral. We may be processing a project on behalf of a certain applicant, but everyone is our constituent. You as the community planning group, the neighbor who doesn't like the project, the applicant, and everybody in between. The development project manager's role is to connect people with the information that they need. Next slide, please. We're all here tonight because we recognize that community planning groups also play an important role in the discretionary development review process. Although your recommendations are advisory, with 52 community planning areas covering a population of 1.4 million people, you are the recognized experts in your community's specific issues. Staff and the decision makers, it's more likely than not that they don't know your specific community as well as you do. Next slide, please. So during project review, the project plans and application will be routed to the community planning group by the city. The CPG, the community planning group, is a reviewer in our system. Comments are entered on your behalf by your development project manager. Assessment letters are prepared at the end of every review cycle, and these will also be forwarded to the community planning group by your development project manager. These are a very valuable tool. They outline major project issues, required permits, they describe the process level, and what's next for the project. Are we ready for hearing? Do we need to resubmit? So the chair is going to be sent a copy of every assessment letter, which is available about a week after project review is complete, which can be anywhere from 3 to 5 weeks after that submittal was made, depending on the type of project. Next slide, please. Planning groups are at their most effective when they review projects based on your adopted community plan goals and policies. Again, you are the technical experts for your community plan. Providing the city clear written recommendations relating your community plan to required permit findings from the municipal code is essential. Next slide, please. Planning groups may recommend approval, denial, or you may recommend approval with conditions. Should your group choose to recommend conditions, it's important to know a couple of things about conditions that can go in a permit. Conditions must have a nexus to the project. They must have a clear relationship to the project itself. They must have a trigger. When does this condition go into effect? Prior to building permit issuance, prior to final inspection, etc. They must be proportional to the scope and requested action. It may be proportional to a request of a couple of additional street trees, but not to plant a whole city block on both sides for a small project. Conditions must be enforceable and measurable, and they may not be included in the permit. Next slide, please. So here's some resources for you. All of our agendas are available online for hearing officer, planning commission, and city council. Also, I forgot to put this on the slide. You can sign up for the mailing list for your own community to receive all public notices in your community planning area. This will also notify you of public hearings as well. And that would be on the planning department's website. It's sandiego.gov/planning. There's an orange subscribe now button on the right, and then it takes you to a list that you can select from. Next slide, please. Ideally, the decision maker's decision will implement the CPG's recommendation. If not, the community planning group is eligible to appeal, and appeals filed based on the community planning group's decision, if they're consistent with the decision, they do not require an appeal fee. Effective appeals will succinctly state how the project relates to your community plan goals and policies. And with that, I will turn it over to Liz Shearer-Wynn for discussion on CEQA.
Good afternoon. My name is Elizabeth Shearer-Wynn. I'm the program manager in the Development Services Department, and I'll be providing you an overview on CEQA. CEQA stands for the California Environmental Quality Act, and it was established in 1970 and is one of the foundational environmental laws in California. Next. CEQA requires public agencies to consider the environmental consequences of their discretionary actions. CEQA is intended to inform government decision makers and the public about the potential environmental effects of a proposed activity and to prevent significant unavoidable environmental damage. Next. CEQA applies to projects that require discretionary actions or permits from a public agency. The proposed activity must fall within the CEQA definition of a project and has the potential to cause direct or indirect physical changes to the environment. Next. An activity is considered a project when an agency builds it. This could include public work projects like stormwater improvements or pipeline improvements. Next. Or when or when the city funds it. This could include actions such as purchase agreements of city-owned property or actions to budget street repairs. Next. Or a project could be the issuance of a discretionary permit, like a coastal development permit for a new home. Next. Who implements CEQA? The city is a lead agency and has the principal responsibility for carrying out or approving a project. There are times the city acts as a responsible agency and is able to rely on other lead agency CEQA analysis. An example of this would be a new public school proposed by a public school district, and the school district is their own lead agency. The city, in that case, would be relying on that lead agency's environmental document. But for the most part, the city of San Diego prepares, well, let me backtrack. The city analyzes and prepares their own environmental documents. Next slide. Unlike other members of DESD reviewing team, EAS does not make any recommendations to approve or deny a project. Per the Land Development Code, EAS is required to produce a legally defensible document with unbiased analysis and maintain independence and objectivity while conducting the environmental review. So we're not here to either approve a project or deny a project. We are just there to disclose what the impacts are and what the mitigation are. Next. Generally, the CEQA process for environmental staff in DSD is as follows. An activity is proposed. It is reviewed to determine the project's process level. And if it's determined to need a discretionary permit, environmental staff are assigned. And as the lead agency, environmental staff would review the project using the city's CEQA significance thresholds and eventually make an environmental determination. Next. The city's significance determination thresholds is a document that staff uses as guidance for determining significance of an environmental impact. This document is periodically updated based on new issue areas, research, or case law. So an example would be noise, construction noise, for example. In our significance thresholds, we identify that any project that would exceed a 75 decibel at the property line could result in a significant impact and could require mitigation, such as noise walls or sound blankets or something like that. Next. There are a number of CEQA determinations that are, that we can choose or not choose from, but can make. This is based on the issues that are analyzed as part of the preliminary analysis of a project's potential environmental effects. It helps us determine the appropriate CEQA document to prepare and provides the supporting documentation for that environmental determination. Once an analyst has enough information to make an environmental determination, they will identify the type of document that will be needed for the project. If a project cannot be exempt but does not have any impacts or impacts do not rise to a level of significance, the document will be a negative declaration. If a project is found to have significant impacts but can be mitigated to a level of less than significant, then a mitigated negative declaration will be prepared that discloses what the mitigation will be. If a project has significant impacts that cannot be fully mitigated, staff will determine that an EIR should be prepared. Next. All draft negative declarations, mitigated negative declarations, and environmental impact reports are required to be circulated for public review and posted to the State Clearinghouse website. So the public review ranges between 20 to 30 days for a negative declaration and a mitigated negative declaration. 30 days for a notice of preparation, and we prepare those for when an EIR goes out for public review to let the public know that we are in the process of preparing an EIR. And then once an EIR is prepared and it goes out for public review, that public review period is typically 45 calendar days. But there are instances when it can be reduced down to 30, but we have to get approval through the State Clearinghouse. Next. At the end of the public review period, the lead agency considers comments that have been received during the public review. All comments must be responded to in writing and become part of the final document. Next. Once the document is finalized, the document still needs to be adopted and/or certified. The decision maker must consider the final document, the comments and responses, and public testimony. Then they will adopt and/or certify the final document, adopt the mitigation monitoring and reporting program. And if it's an EIR, they will also adopt the CEQA findings and statement of overriding considerations. Next. The City of San Diego also has a public noticing process referred to as the Notice of Right to Appeal. These notices are required for exemptions under a process 2 through 4 and for environmental documents prepared under a process 2 decision, and they must be posted for 10 business days. This allows the public to appeal the environmental determination that was made. Next. A notice of determination is filed within 5 working days after final project approval. So once a project has gone to hearing and the decision maker has made or has adopted and or certified that environmental document, city staff has 5 days to post a notice of determination. And what that does, it sets the time limits on legal challenges. And if it's done within the 5 days, it sets the time or the time period to 30 days. And if it is done after the 5 days, it is 180 days that someone can file a legal challenge on that decision. Next. The Land Development Code establishes what environmental determinations can be appealed. It does not allow for appeals of previously certified documents nor decisions that have already been subject to council approval. The code defines environmental determinations as exemptions, negative declarations, mitigated negative declarations, and environmental impact reports. Thank you. Back to you, Marlon.
All right, thank you, DSD staff. Do we have, before we take a break, do we have questions of staff?
We do have a few questions that came in. One was, what is the process for reviewing and submitting comment on projects, and how to clarify the timeline for providing comments from the community planning group?
So I'll take that. This is Travis Friedman with Development Services. There's the official comment we would get from the community planning group would be in the form of your vote and any recommendations or clarifications you might have for the record on that vote. But that doesn't mean that informally during the process, we're not responding to inquiries and possibly entering relevant comments at that time.
All right, great. So we also have another question, which I believe Michael Prince would like to answer live, which is where can the land development code be found?
I actually did not want to answer it live. I was trying to type it in, but it can be found on the city clerk's website, the municipal code. I'm happy to post the link in. Just as a point of clarification, the land development code is comprised of chapters 11 through chapter 15 of the municipal code. And so that outlines everything from definitions to permit procedures, base zones, supplemental regulations, which cover accessory dwelling units, parking regulations, landscape regulations, and then finally plan district ordinances within chapter 15. So those are all separate chapters and they're all on the city clerk's page within the municipal code, and I'll type in the link to the municipal code shortly. Thank you.
All right, thank you. So I believe those are the questions for the Development Services Department. I'll pass it back to you, Marlon.
Okay. All right. Again, thanks everyone. So what we'll do now is take a 5-minute break and be back at 6:15. We're a little ahead of schedule. So let's do that. Right, ladies and gentlemen, welcome back from the break. In the break, we did receive a question for our staff regarding the definition of a project and how would the November 2020 Measure E effort to remove the height limit from a specific area qualify as a project. And it sounds like a hot button issue. That's something that our environmental staff is going to look into, and we will forward that answer and share that with you at a later date once we look into that a little further. So we're going to continue with the rest of our agenda this evening. So our final item this evening is a guest panel Q&A. And now I would like to turn it over to our Planning Commission Chairman, Bill Hoffman, who will be moderating the panel. Bill?
Okay, thank you. And first of all, staff, thanks for all of that input. I've been doing this as my third time at one of these meetings, and I learned something every year. So I really appreciate it. Very good detail, a lot for people to digest, but you'll definitely get used to it as you continue on. So we have a very good panel here tonight I'd like to introduce. From the City Attorney's Office, we have Noah Brazier, Deputy City Attorney. From the Planning Commission, I have two of my colleagues, Mr. Ken Malbrough, Planning Commissioner, and Kelly Modane, Planning Commissioner, and a Community Planning Group board member who was a current CPC chair and a past Planning Commissioner, Barry Schultz. So with that, we'd like to kind of go into a question and answers panel. I'll be moderating, and I'd like to start with Noah. Just a question for you is, does the City Attorney's Office directly support the community planning groups? And if so, how would you describe that support?
Good evening. Yes, it's important to understand the roles of the City Attorney's Office. Since my client is the City of San Diego and it's not the community planning groups themselves, since the community planning groups are independent entity, I can't provide direct legal advice to a community planning group. However, as a legal representative of the city, I can help clarify questions or issues that may come up and maybe even resolve some ambiguities in any rules. So yes, questions can be directed to my office, but again, it's subject to the limitation of whether or not I can provide you legal advice. So.
All right, thank you for that. And just a follow up to that, why then are the community planning groups subject to the Brown Act?
That's a good question. They're subject to the Brown Act by agreement. So one of the conditions of being recognized by the City Council as a community planning group is to agree to comply with the Brown Act. So that commitment by a community planning group makes community planning group members obligated to follow the Brown Act and its provisions. Now, all of them might not apply the same as they would to like a government organization, but because of that commitment, community planning group members are expected to follow Brown Act rules and provisions.
Okay, which would be a very good reason for everyone to really pay attention and learn what those provisions are. Switching over, I want to switch down to Barry Schultz, who's a community planning group board member, past planning commissioner. And Barry, how do you use as a community planning group board member your community plan when you're making your decisions?
Well, good evening. So I'm in the Carmel Valley community plan area, and our community plan was adopted in 1975. At the time of its adoption, obviously we were really a symbol of greenfield development. And Our community plan called for phased development by neighborhoods. We have about 10 neighborhoods that were developed over that time. Each of those neighborhoods had specific goals and policies that affected the development of our community. Focused on land use, making sure that we had integrated land uses, connections between our residential and our commercial. And we also have a pretty good workforce area designed as well. It dealt with circulation and public facilities. So during the development of our community, all of our planning groups were always focused on making sure that developments occurred in accordance with the policies and the objectives that were set forth, not only in the community plan, but also in each of the specific neighborhood areas. The plans also provided for procedures. I know we had some conversations today about amendments. So our plans also provide a very specific procedure for each of the amendments, and they also provide a procedure for substantial compliance. Those also have findings. And so as part of our decision-making, if there was an amendment, we'd have to make sure that those amendments were consistent with the plan, and also we can make the findings to support the amendment. Today, our community is pretty much built out. We have some small infill projects that are occurring, and in those cases, we're looking specifically to the neighborhood plan and the policies and goals that are relevant to that plan, and making sure that those projects are consistent with that. For the most part, today, we are really focused in the projects that we do get is making sure that those projects are not only consistent with the policies and objectives, but also are consistent with the development regulations. And that's probably where we spend most of our time, is focusing on those development regulations and making sure that the project is in compliance with that.
Okay, so in other words, that community plan is a critical component of your review. And just to follow up, Barry, as a former planning commissioner, what do you look for when reviewing recommendations from community groups, and how do you use that former knowledge in your conducting business with the community planning groups?
So the first thing I'll say as a planning commissioner, and I probably speak for the existing planning commissioners as well, is that we take the planning group recommendations very seriously. And I know that was always an issue that many people in community planning groups had, is whether their recommendations really matter or not. When I was a commissioner, that was the first thing that I would look for, is what is the planning group's recommendation. And what I would be looking for is, one, was it a unanimous recommendation? Was it simply a consensus? And if there were a split vote, then I'd want to understand specifically what those issues were, so that I can understand how those issues got resolved in one favor, but I also understood where those who voted no against the project, where they stood. I think in getting recommendations from planning groups, it's very important that you tell a story. So some of us don't live in the neighborhood, and it's important that those recommendations give us a flavor of the neighborhood, and then they're specifically tied to the findings that you're required to make. And to the extent that there are certain policies or objectives that are in your community planning plan or in your development regulations that the project isn't consistent with, it's really important for you to articulate where those issues are and what facts you have to support your position.
All right, thank you. I'm gonna move over to Ken Malbrough, Planning Commissioner, and Ken, maybe following up to that a little bit. In your perspective as an acting planning commissioner, how detailed should the community planning group's recommendations be?
Well, thank you. And first, I just want to thank all the members who are on the CPGs that are here tonight for your hard work. I have done this for about 8 years, and I know how much time you have to put into it, and I greatly appreciate that. So actually, Barry kind of did a pretty good job in answering that question for me with your follow-up. But I will say that the information that the planning groups give to us is very critical. I mean, you're where the rubber meets the road. You represent your planning area, you represent your neighborhood, and as much information that you can give us is extremely important. Now, we do get your votes, and sometimes your conditions that you may have. But here's something that I would add to that. In our voting process, usually if it's a unanimous vote and with staff's recommendation as well, that's pretty simple. But it gets a little dicey for me if it's if it's not a unanimous vote. I'd like to know why. I'd like to know more information as to what was the discussions on that. It helps me in determining that. Also, if it's a unanimous, if you don't agree with staff, if it's the opposite, I would like to know why. That's great information on that. And so moving on, also, as far as other information, and you have, and I'll tell you how you can do some of these. Some of you, it's probably already been covered, but when you do like conditions, what we find a lot of times is it'll just say minor information. Give us more detail as to what are those conditions, and also record what the applicant has said, whether they agree with that or not agree with that or not said anything, so that we can further question that applicant during our process with this. So the question becomes, how do you give more information? Again, you can use the distribution form, and I assume that you probably went over that, but there's ways that you can provide more information than that. We definitely read that, but you can also just attach your minutes as well. But the important thing is provide us what you want us to know, because it's your area. This project is going in to help you and your fellow neighbors, and so it's important that we listen to you.
No, that's a very good comment summary. I found, I'll just add to that a little bit. I found that all community groups are not equal when it comes to providing us information. We get some really terrific minutes, and it really gives us a full flavor of the issue. And we have others that will see like a 7-5 vote with no explanation of what the dissenting vote was. And you'll find at our planning commission meetings, we ask that of staff. Hey, why did the 5 people vote against that project? Tell us. We really want that extra color to it, because that really helps make our decisions. So that was a good point, Ken. And switching now to Kelly Modane, another planning commissioner. How do you balance the applicant's perspective with the community's interest when making a decision on a development project?
I want to echo what Ken said about the effort that it takes to be on a CPG. So I do want to thank everybody that is new to this, and we need community volunteers such as yourself. I also want to echo what Ken and Bill said about providing enough color on your vote. Before I go into the next question, many times we get just the vote, or sometimes we get the meeting minutes, but sometimes meeting minutes are not completed or approved before we hear the items. So sometimes they're missing from our packet. And so to that effect, if the meeting minutes aren't done, it would be really helpful if there was just a summary paragraph of why there was a split vote, or why certain members of the CPG did not vote in favor of a project, because like both my fellow commissioners said, it's very important information for us to have in our vote. Weighing the applicant and the community's perspective can be challenging. It depends on, I mean, each project is, site specific and community specific. So we have to hear what the opposition is, and if it's opposition that is merited, and also what the applicant's perspective is. And I've been on many hearings where we've heard kind of differences of opinion on approach for a project, and we've asked the opposition, in more detail, what could the applicant do? And then we've asked the applicant if they're willing to kind of meet in the middle, and we've conditioned projects accordingly. So it really just depends on, what the community is giving us feedback on, why they don't like something. There are some limitations that we have as planning commissioners that state law prohibits us from denying certain projects, but we try to weigh both and see if there's something that we can meet in the middle.
All right, thank you. Thank you. And Barry, back to you. You're actually going to take on a couple of questions I was going to ask Frisco White, who couldn't make it tonight. As chair of a community planning group, I know you were the CRC chair, but how do you facilitate discussions so that you can come up with an effective recommendation from the group?
So I think, you know, our planning group, our approach is that we take the approach that we want to get to yes. And we will have an applicant provide a presentation on their project. And we will review that, that presentation against the decision framework that we have in front of us. And then we try to facilitate questions from each of our board members. One of the things that I have found is that everybody has different expertise. I'm a lawyer, so I'll be kind of the stickler for the code and those types of things. We've got architects who are more focused on design. We've got some engineers that are really into traffic. And what we try to do is play to everyone's strengths and that they can question that. We then move to the public, and we will have people from the community express their concerns about a project. And we're pretty good about facilitating that comment from the public and making sure that it's very clear as to what their concerns are. Once we have all of that on the table, then we're looking for solutions. So a lot of the times there might be problems with traffic, there might be problems with the design, and we'll have a conversation about solutions, and we'll solicit solutions from the developer, as well as from the community, as well as our board. And like I said, our focus is getting to a yes. There are times where it's necessary to continue a project, because one of the things we try not to do, which is very hard for some of the architects on our board, is to redesign a project on the floor. As many people know, you make a change here, there are domino effects. So we want to make sure that there's sufficient time to review any potential changes. If in fact we do continue a project, we want to make it very clear to the applicant what the issues are, so that they know exactly what they need to focus on, and they're not walking away with just the feeling like nobody likes their project. We really focus on being very articulate about the issues and where they sit within the framework of our decision making. And again, we want to try and encourage the developers to take those issues to heart and to make those changes. And quite frankly, I think we've been very, very successful. I think many of the developers that have worked with our planning group have felt that when they were done with their project, incorporated some of the changes that were requested by either our board or the community, they felt like they had a better project for the community.
Well, that leads me to a follow-up question about that. That's a good point. Is how seriously, in your experience, do developers take the community planning boards?
My experience has been good developers do, and there have been a lot of good developers. And when they are provided with thoughtful comments and thoughtful concerns, they usually go over to get to a yes. And from a developer's perspective, there's a couple of things. When they come to you as a planning commission, they want to have staff support and they want to have the community support. And if they have those two, they know they have a better chance of getting their project approved. So my experience is that developers have been very willing to take into consideration comments from community planning groups, provided that they're fair, provided that they're reasonable. And one of the toughest things sometimes is that developers will come to a planning group and their project will have, let's say, 3 or 4 iterations that occurred. And by the time they get to the planning commission, and then you're asking them for some additional changes, it's a little tough. So what we try to do is make sure that we address as many issues as we can, and that when it gets to the planning commission, at least from the planning group's perspective, it's a good project, and that we're not relying on you to continue to modify it, because we hope that we've given a recommendation of support for a very good project from our community. Now, on the other hand, there are those developers that won't do anything, that basically check the box. They come, they listen, and they're moving forward. Some of them may feel like, hey, we don't really need to hear from the community planning group because, you know, we'll go to council and we got sway there. But I have found those to be few as opposed to the ones that are good partners.
You know, and when that happens, we know that too. When that happens, they typically do not get a good reception at Planning Commission. Going back to something I brought up earlier, and Ken and Kelly, I'm not sure if you'd heard this or not, but I talked a little bit, and I want to get your perspective. I talked in the introduction that sometimes we don't agree with Planning Commission or Planning Community Board recommendation. It's not very often, but it happens sometimes. And I wanted to ask either one of you, or maybe both in turn, your experience, if you've had an experience where you voted against a community planning group's recommendation, and what was the thinking behind that, just generally speaking, not specific to a project, but just generally what's going through your mind?
I'll jump in. This is a very, very rare occurrence, and I can only think of one off the top of my head. But there was an appeal in the La Jolla Community Planning Group area about, it was an addition on a home and a conversion of the garage to a living space. And I believe that they had denied the project, and then there was an appeal, a coastal development permit appeal tied to that. And I disagreed with it because of the ADU laws and the ultimate use of that garage. So, you know, I think it just really depends on what specifically are the concerns. And on that particular one, I did not feel like the concerns were merited. So I approved the project and denied the appeal. But that's really the only one. Generally, when there is consensus from the community planning groups on a specific item that is merited, we really do listen and try to see what we can do to condition it, or, you know, have the applicant address it.
Ken, how about you?
Well, you know, I'm barely over a year, and so I can't recall of any items that the planning group was 100% against, but I've seen a few, and I agonize over it again because of my background with planning groups, and I know how tough that can be. But when I get to that kind of situation, I really have to look what's overall best for the neighborhood and the planning area, and how it relates to their community plan. And that's when I start looking at the numbers and the codes, and then I just make my decision, be guided on that.
Okay, good. Yeah, and the point I was making was that sometimes, not often, and I've been on, I guess going on my 7th year, that there has been times where we've overturned a community group's recommendation, but in my experience, it's always been due to trying to balance that specific community issue with the citywide goals. And our group, really the Planning Commission is really charged with looking on a citywide basis, but it's very rare. And there's no malice, there's no, 95% of the time we see unanimous vote coming or majority vote coming from a community group, we follow that in most cases. So, but it does happen sometimes, and I just don't want anybody to ever take offense or take it personally, because it's definitely not, and we really need that input. Barry, back to you. Last question for you, but it can maybe morph into more. as a former planning commissioner again, what is your focus as the chair of a community planning group? Do you focus on specific topics? Like we're getting into a little bit more of the detail as you look at a project. What types of things do you want your group to focus on when you're looking at a development project?
So the first thing that we focus on is how does the project fit within the community? And that each project is different. So it may be density. It may be design, whether it's height. Sometimes it's landscaping. It could be a lot of different issues. But most projects come with some type of a specific issue. Today, density is a big issue, and trying to, particularly in our older communities, have projects that are of a right size to fit and be integrated into the community and be consistent with the current infrastructure is always a struggle. For my community now, mobility is a big issue. And we are focusing a lot on transportation issues, circulation issues. You know, I mentioned before that our planning document was adopted in 1975, but it was pretty progressive. And it really did talk about circulation issues, biking, public transportation, et cetera. Fast forward to today, we don't have one bus servicing our community. So when we start talking about alternative transportation, it's been a struggle for us, because although we had some bus centers identified in our plan, they never came to fruition. And unfortunately, I don't see that happening anytime soon. So what we do focus a lot on is circulation, the streets, doing the complete communities issue in terms of getting bike lanes, those types of things.
Oh, great. Thank you so much for that. That kind of, I want to now open it up to the panel and know you as well. Any other comments you'd like to make before we go to some questions from our community board members?
I would like to kind of echo what Barry said. You know, with the new wave of, you know, focusing on transit-oriented developments. I know that's been, you know, TOD has been a term that's been tossed around for a really long time, but now it's really becoming critical with our housing crisis and our climate crisis. So, you know, personally, I look for higher density projects around, you know, TOD stations and things of that nature. And sometimes the density is something that community planning groups are not terribly supportive of, but it is something that we need to address. And those are the prime areas to focus that density with.
Okay.
I just wanted to add, as a chair, I try to do 3 simple things to try to get, because in my situation, I did not have a vote unless it was tied. And so I kind of felt like I was more like a referee in the meetings. And so always wanted to, first of all, I needed to do my homework, and I really needed to understand the project. And if I didn't, I needed to make those phone calls to DSD or planning, whoever it may be, to get the answers on it. And keeping everyone on track, but giving everybody on your board an opportunity to talk. Sometimes that makes the meetings long, but I've seen where I was not a chair and where sometimes people would not get a chance to have their input. And that just wasn't the right way to do things. And lastly, one thing I like about the Planning Commission, what we do, because it does so many things, is we're allowed to ask clarifying questions. And yes, we're doing that to get some clarity on something, but it's also a good tool to help others think about, oh, wow, I didn't think about that particular subject. And while maybe that's what the applicant needs to get across to the board members to ensure that they have everything that they need to make a sound decision.
Good point. Very good point. Okay. we have a few minutes left. Staff, if we're all here to take questions. If there are any out there, if anyone has a question, I think you can just go to the chat and ask away.
Hello, so just to jump in, oh, take it away, Marlon.
Okay, I just wanted to follow up on a question that was asked during the break from one of our attendees relative to the definition of a project related to the November 2020 Measure E effort to remove the height limit from a specific area and if that would qualify as a project. And so we did get a response from our EAS staff regarding Measure E. The Planning Department prepared an environmental impact report and currently it is out for public review. Projects are defined under CEQA section 15378, where projects could have their own unique circumstances and where one action could be defined as a project under CEQA, another may not. So there we got that response from EAS. Thank you very much. And go ahead, Suchi. Did we have any more additional questions?
Yes, we actually have the opportunity to take a few questions live. And so in order to do that, you can use the raise hand feature, and then I can give folks permission to mute and unmute. So you see the hand in the corner of my screen, that is the raise hand feature. So I see a few folks have raised their hands. I will go ahead and start with Helen Boyden. You should be able to unmute and ask your question, Helen.
Okay, I will first state that I am not a new planning, new CPG member. Marlon knows who I am. And rarely do we have a process for, and I've been on a subcommittee, rarely do we have a process for that goes to the Planning Commission. Well, I am a member of the La Jolla CPA. Rarely do we have a process for a project that goes to the Planning Commission. So unless it's an appeal of a process 2 or a process 3, the Planning Commission is looking at something that the Community Planning Association has turned down. And actually, the record is that we don't turn down many projects. And so when they go to the Planning Commission, you know, it's relatively rare, but on the other hand, because we're in the coastal zone, we do see a lot of projects. And we don't feel that we have very good success at the Planning Commission, or at least in the past that I've got that. I don't know the one that Kelly spoke of. I'm most familiar with things in the La Jolla shores. And so I'm wondering, in the first place, there aren't going to be many appeals in the future if they remove the waiver for the $1,000 fee. And so I'm just wondering how we could do better. Are we not providing enough detail to substantiate our position? I'm not the one writing these things, but we have tried to get our subcommittees, if they're denying a project, to put as much detail in as they can, because we found out someone, oh, we're trying to do that, and I don't know if they're doing that. So if anyone could offer something, it doesn't have to be, please don't make it specific to La Jolla, but I just wanted to let you know where I'm coming from. And I'm not writing these things, so I just vote.
Sure, understood. And just raise your hand if anyone would like to answer that, and I can start. Yeah, I you know, being on the Planning Commission, probably the longest of the active members now, we definitely get a lot of appeals in La Jolla. I don't know why, it just seems to be one of these planning areas, and I think it's due to the real keen interest that the board and citizens have in their community in planning process, and that is a positive. And I think, as we mentioned before, having more detail always helps I've seen appeals come from the community boards, and I've seen it from next door neighbors. I've seen it from a lot of next door neighbors. There's a lot of appeals. And the more detail we get, the easier it is. But admittedly, I will say that I've seen generally, I don't know why it is, but the Planning Commission in the past, I don't think this commission has been pretty tough with La Jolla. And I don't know why that is. I just don't know why that is, but I think it's just looking at the findings. I think that's the thing that we look at. Can the findings be made? The appeals that come forward from the Community Planning Board, are they really legitimate appeals based on the findings, based on the facts of the requirements of the community plan? And I'm hoping that won't be a problem because we take it seriously from all communities. So well, I didn't answer your question, but we will try much better.
I just want to add that we also look at what the appeal is based off of and in comparison to the City of San Diego Municipal Code and how staff responds to that complaint in the appeal. And if the applicant is following the municipal code and land development code, if they are, you know, then me personally, I follow what the code says. And so that's really where I think we're coming from. And many times in those appeals, there isn't anything strong enough that would, you know, counteract what's in the municipal code.
Yeah, I was just going to.
Yes, please, Ken, please go.
Yeah, I was just going to add what Kelly said, that you know, you listen to both sides, you take in the facts, and then you look at the rules, the codes, that is, and that's how you have to make your decision on that.
Yeah. Howard Wayne.
All right, I will be giving Howard permission to unmute.
Okay. Good evening. I want to direct a question to the Planning Commission members who are here. And in your experience, when a CPG appears before you and makes a presentation, do you ever engage in dialogue with the representatives of the CPG?
Ken or Kelly? Or go ahead.
I have, Mr. Wayne, for you, I have not actually. I try to, I miss sometimes going to the CPG meetings, but I've stayed away from that. And I really, when I know of a project that that's maybe in the community that I live in, I actually kind of avoid it because I know I'm going to have to make a decision at some point in time.
And was that your question? Is that what you're asking about, is at the CPG meetings? Wayne, are you still there? I'm sorry, Howard.
Yeah, let me clarify if I didn't get it straight, that I'm talking about when a CPG member appears before your commission and makes a presentation. Do you, as a planning commissioner, engage in dialogue with the representatives of the CPG?
And let me take a stab at that. You know, as chair, we take account of the recommendation that's given to us in the staff report, and that's where we really like to see the detail. We definitely want to hear from the CPG board member, but we don't engage in dialogue. It's like anybody else. We do if we have questions. We definitely do if there's questions, but we don't start a discussion just because they're from CPG, but we listen very carefully. And if a question comes up, we will definitely ask that question. And oftentimes we do of, hey, why did it go this way? What were the people dissenting? What were their concerns? Things like that. Kelly, I'm sorry, I didn't mean to cut you off.
No, I was just going to say, I think it's rare for a CPG member to make a presentation to the commission unless they are the applicant or the repellent. So I have not really seen the CPG make a presentation specifically where we would ask questions. We have had many CPG members speak on an item, but that's during public comment, and we don't engage in those comments. We just listen to them and take them into consideration.
Helen Boyden.
All right, Helen, you should be able to unmute.
Answers to my question really focused on the municipal code, and yet most of the comments that come from the commissioners say they're with respect to the community plan. And to what extent, if people say what's in the community plan, how much do you actually, how important is that in your decision?
Well, okay, and just unmute yourself, Ken and Kelly, and I'll let you speak. But for me, and Kelly mentioned this earlier, we try and look at the facts, and we look at the community plan. We make sure that the community plan is consistent, and that hasn't always been the case, where there's been sometimes an inconsistency between the community plan and the municipal codes, some of the zoning regulations, but we definitely look at it very carefully. That's really is that community's general plan, if you will, that the code should be consistent with, but we definitely look at that.
I guess you're waiting on me, sorry. No, I just, I go back to, that the community plan is important to me, but if it's consistent with the codes, that's even better. But then if it's not consistent, then I have to look at the facts. Again, it's pretty much the same as Chairman Hoffman said.
Yeah, I don't really have much further to add. Some projects are by right, and if they're being appealed, we look at the land development code. If they're larger projects that are, a process 4 or 5, we of course look at what's contemplated in the community plan, and also staff's recommendation that's in concert with that community plan.
And you made a very good point that the vast majority of projects don't make it to planning commission. They're typically at a level 2, level 3 that you see. So there's not a whole lot, but everyone that comes to us though has gone to you first. So everything we see has your recommendation, and just to kind of reinforce that point, we definitely look carefully to your recommendations. And I see we're right at 7. Staff, I don't know, it's, let me just ask any last comments from any of the panel? And I just want to say, if not, I just want to thank, those were really good questions. I want to thank everybody, and congratulations again for your appointment and for your service to the city.
Thank you, Bill. Just before we sign off, I wanted to capture one last question, and it's in regards to ministerial projects. Is there any requirement for the developer to present the project to a community planning group? And they've mentioned that I've attended a number of community planning group meetings, and those that have come voluntarily, the developers, really get hammered at the meeting, especially if it's a dense project or doesn't have parking. To answer the question, we do get projects that are presented to community planning groups, and oftentimes or sometimes they are undergoing a ministerial process. Typically in my experience, the planning groups are appreciative of those presentations from developers despite just going through a ministerial project, because at least they know what's coming down the road in terms of a proposal. So I haven't had any experiences where the applicant was met with harsh comment. Usually most of the planning groups I deal with are appreciative, like I said, and welcome the information. Now, there isn't a requirement, of course, in Travis's presentation. The projects that community planning groups do not see are typically ministerial, like building permits or projects that meet every letter of the code, and therefore meeting those requirements get to proceed ministerially. And so it's the discretionary projects that come before the planning group where the planning groups have a lot more say. But we don't encourage. Well, actually, we do encourage applicants to come before the planning group just to give planning groups an FYI about what their proposal is. All right, thank you for that last question. And we'll go ahead and wrap up. So this concludes the training for our new community planning group members. I would like to thank all our guest speakers, the staff presenters, and of course, you community planning group members for volunteering. So this concludes our presentation. Thank you and good night.